Today on Uncommon Knowledge, detaining enemy combatants. Should we make a federal case out of it?
Funding for this program is provided by the John M. Olin Foundation.
Welcome to Uncommon Knowledge. I'm Peter Robinson. Our show today, in prosecuting the war on terror, does the government of the United States have the right to place enemy combatants in the clink and throw away the key? The United States now holds more than 600 persons captured in the war on terror at our naval base in Guantanamo Bay, Cuba. We are holding them indefinitely, without charging them, and without providing them access to legal counsel. A couple of cases now before the Supreme Court ask whether such treatment is legal. The court is expected to hand down its decision by this summer. How should the Supreme Court decide? Joining us today, two guests. Erwin Chemerinsky is a professor of law at the University of Southern California. John Yoo is a professor of law at the University of California at Berkeley and a former member of the Bush administration's Department of Justice. The Supreme Court of the United States in the 1936 case Valentine versus the United States, quote, "The Constitution creates no executive prerogative to dispose of the liberty of the individual. Proceedings against him must be authorized by law," close quote. We are now detaining more than 600 persons captured in the war on terror at our naval base in Guantanamo, Cuba. We are holding them indefinitely, without charging them, and without providing them access to legal counsel. Is the behavior of the government of the United States toward those detainees, quote, I quote the Valentine case again, authorized by law? Erwin?
No, it's not. It's a violation of American law and international law.
John?
It's constitutional and legal under both international and domestic laws and exercise of the war power.
We now proceed to mud wrestle, gentlemen. First question, are we truly at war? If so, then the laws of war apply to anyone we capture, but if not, if the war on terrorism is simply a more virulent form of a social or criminal problem like the war on drugs, then we ought to be talking about domestic and international criminal law. So the question is, did September 11th start a true war? You agree that it did? That's not a controversial matter for you?
It's certainly both a war and a law enforcement matter, but I don't think that that determines whether or not those in Guantanamo should have access to the courts.
The question is, if you decide it's a war, then naturally you have to ask about what are the powers that commanders-in-chief and the presidents have exercised in war. And in every war, we have always taken people as enemy combatants. Think of the hundreds of thousands of people who were captured in the Persian Gulf War. Right? There was no special statute passed by Congress authorizing them to be captured and detained. They were captured by the president and the subordinate military officers under the laws of war, as you said. And this is a traditional power of the military and presidents under the Constitution. They were never given lawyers. They never had federal habeas corpus rights.
The Third Geneva Convention, to which the United States and Afghanistan, where most of these detainees were captured, are both signatories, lays down strict rules for the treatment of prisoners of war. Erwin Chemerinsky, I quote you to yourself, the United States government has ignored all of these requirements, close quote. State your case.
The Third Geneva Accords, as you point out, says that when a government is holding individuals, it has to provide a prompt proceeding before a competent tribunal to determine if they're prisoners of war or enemy combatants. Secretary of State Colin Powell, 2 years ago, in March of 2002, said we need to provide these tribunals. It's never been provided. What distinguishes John's example of what's occurred previously is never before has the United States government said we can apprehend individuals and hold them indefinitely. In fact, President Bush says the war on terrorism go longer than any of our lives. Hold them then for the rest of their lives without any access to any tribunal whatsoever.
John?
There's a number of things to say there. First, there's two kinds of detainees. There's the al-Qaeda detainees and the detainees picked up in Afghanistan. I don't think anybody seriously is claiming that the al-Qaeda detainees are entitled to the Geneva Convention rights because they are not fighting on behalf of a state.
You would not so maintain.
There has to be a competent tribunal, and those are the words of the Third Geneva Accords, to determine who is from al-Qaeda and is an enemy combatant versus a prisoner of war. We've never had those
I don't
tribunals.
think that's right. First, you have al-Qaeda detainees. They're just not entitled to any Geneva Convention rights because they are not fighting on behalf of a state that signed the Geneva Convention. Then there is the people who fight on behalf of Afghanistan during the military conflict in the war there. Those people do get the Geneva Convention rights of some kind, but the provision you're talking about says they get a competent tribunal, which in the past historically has not been a federal court. It has sometimes been just 2 or 3 officers in the field who examine someone who's captured in the field. Those people get a right to a tribunal if there's the treaty says if there's any doubt about their status.
Okay, let me interrupt you. Let's take a look at each of the tests used to determine a prisoner's status. The Third Geneva Convention lays down 4 tests for whether someone captured in combat is or is not a prisoner of war versus an enemy combatant. And I'd like to go through these tests. They're quite simple, and see how you both respond to them. The members of the militia in question must be, quote, commanded by a person responsible for his subordinates. True of the Taliban, John?
It's unclear because according to, I think, that provision, that means that there has to be a commander who enforces the laws of war and discipline on their troops. And it doesn't appear, as far as we could have told it when we were fighting this war, that the Taliban met that. The Taliban seemed to be this kind of a mob that...
You are saying positively they failed to meet that test?
Yes.
Or simply you are saying positive?
2 things. First,
You'll let that test go? Or, go ahead.
First, the question is, who makes this determination? I don't believe it's a determination to be made by John Yoo or the president. There has to be a tribunal to it. But second, I also disagree with this characterization of the Taliban. As awful as they were the government ruling Afghanistan, and they clearly met that first test. They were commanding an army.
Second test. The members of the militia must wear a, quote, I'm quoting from the translation in English, the Geneva Convention, a fixed distinctive sign recognizable at a distance. If not a uniform, then something to set them apart from the civilian population. Taliban meets
Again, we didn't think that they did because some people said they had these turbans and these different colored turbans separated Taliban from non-Taliban. But actually the turbans had to do with their geographic location, where they were from. In fact, a lot of the Taliban, what they tried to do was to disguise themselves and blend into the civilian population so they became indistinguishable. So we didn't think that they met that factor either.
Undoubtedly, some did and some didn't. Again, I think we're avoiding the question of who gets to decide.
You keep saying we thought this and we thought that. Who is the we in this case?
When we were in the government, when I was in the government, I worked at the Justice Department, and so the Justice Department, the Defense Department, and the White House worked on these questions.
Okay,
you know.
2 more tests, and we'll get to deeper questions. I just want to see the way these tests sort out. Test number 3. The members of the militia must carry their arms openly. That they did do, right?
Everyone in Afghanistan carries arms openly, so I don't think they had a problem with that factor.
Okay. Of course. Last one. The members of the militia must conduct their operations, quote, in accordance with the laws and customs of war, close quote.
Right, on that is the idea that if you're going to get the benefits of the laws of war, you obey the laws of war. And I think everyone agrees that the Taliban were notorious for violating the laws of war, massacring civilians, killing prisoners that they captured.
You grant that as well, right?
Obviously.
Okay. So what John Yoo says is, look, the question of who determines whether they're enemy combatants or prisoners of war under the Geneva Convention isn't terribly important because on these 4 tests, they clearly failed 3. It's obvious.
Well, obviously, I disagree with him in terms of whether they fail many of those tests, but I also think that this is the point. The Third Geneva Accords say there has to be a competent tribunal to determine whether somebody's a prisoner of war or an enemy combatant. We could talk about what tribunal. I'm not saying it has to be a federal district court, but it can't be, and I think this is the point we still haven't gotten to.
Right.
It can't be that the United States government can hold human beings for the rest of their life in prison without any access to any tribunal to determine whether it's appropriate.
I think the mistake Irwin's making, I'm not saying it's a terrible mistake, it's just a category, it's a way of thinking about this. Irwin and the plaintiffs in these cases think about this as a criminal law enforcement operation. So you hear it in the way Irwin talks about it. They're in prison. They're being held in prison without criminal charge for the rest of their lives. Right? That is a very American criminal law way of thinking about people who are being detained. The laws of war in the military world, detention is a very different process, right? You're not detained because you're guilty of a crime or you're being punished. You're detained to prevent you from going back on the battlefield and fighting. And you're not detained indefinitely. You're detained until the conflict is over. And Irwin's quite right. Rhetorically, the war on terrorism could be a long time. It sounds like the war on drugs. It sounds like a persistent social problem. But As a matter of
sound like the president, we have it on the authority of the chief executive himself that this will go on for ages.
And I think that's a matter of political rhetoric. But in terms of international law, we have a conflict with a defined entity, which is the Al-Qaeda terrorist network.
Okay, John. Let me push John just a little bit harder on this question of who determines the status of these detainees. Current American military regulations, quote, all persons, this is our stuff, our regulations, not Third Geneva, all persons taken into custody by U.S. forces will be provided with the protections of the Third Geneva Convention until some other legal status is determined by competent authority, close quote. What competent authority overcame this presumption, which is written into our own military regulations, to decide that those 600 and some odd now in Guantanamo Bay are enemy combatants instead of prisoners of war?
It's clearly a presidential determination, and there was a press conference, I believe, and a document issued by the president making the findings about the Taliban and the Al-Qaeda. You know, as I think I said before, the Al-Qaeda one I think is a fairly simple one because they're not fighting on behalf of the state. With the Taliban, the president took in all the intelligence information about the way the Taliban had conducted themselves, went through those 4 factors. I think at a minimum, everyone agrees the Taliban disobeyed the 4th factor, obeying the laws of war,
right.
And the president made a determination as to them as a group. Now, it's true that there could still be doubt about some people, and they would get a tribunal. So, for example, if you were a BBC reporter and you were captured on the battlefield, you weren't even a combatant, you would get a tribunal. But as to people who are members of the Taliban who are claiming, oh, as a Taliban member, legally the Taliban are entitled to the status of prisoner of war, they lose because the president has made that judgment.
Does this not make Swiss cheese out of one of the signal human accomplishments of the 20th century, namely the Geneva Conventions, in the sense that any time the President of the United States wants to opt out of treating people we take in combat as prisoners of war, he just says so. At a press conference, he just declares that they're enemy combatants. There's no appeal. There's no even semi-judicial process established. He just says so. Doesn't that make you queasy?
No, because the president has always been in charge of wartime and has always made these determinations. And so you're right. I mean, it's possible that some president could abuse the system and say, I'm just not going to apply the Geneva Convention to anybody, whether they sign the treaty or not, or how they conducted themselves or not. And, you know, there are political branches like Congress that can respond to that if they disagree. But we have always...
The check is political and diplomatic, the international community. It's up to them to get steamed up over it, as indeed they have. Tony Blair's upset about the way we're treating the prisoners.
Exactly. We've historically given that power to presidents.
All right. No president has historically ever said, we're going to hold people likely for the rest of their life with access to no tribunal. I disagree with John.
Can I just ask, is it the open-endedness of this conflict that creates this, what you would view as a special or an unprecedented problem with these enemy combatants?
Certainly that's what makes this most troubling.
All right.
And what I think is wrong with John's analysis here is it doesn't matter whether you call it law enforcement or war. We're holding human beings in prison without access to any judicial review. According to some administration sources that have been quoted in the newspaper, there are people in Guantanamo by error because we paid warlords for information in Afghanistan of who to apprehend. According to some administration sources and articles in major newspapers, there are people we know to be there by mistake. Now, I obviously don't know if that's true or not, but we can't let one person, even the President of the United States, imprison people indefinitely without any check and balance.
And look, the political system has worked. See, the problem is that you're going to federal court, trying to get judicial review of the Supreme Court and lower federal courts, look at all these people and decide who they are. If you think that, the worst possible way to fight a war, because you don't want the federal courts and judges involved in making decisions about who we're going to detain, how long we're going to detain them, and what we're going to do while we have them. And you can see the political system is working. The Defense Department just recently announced that it is going to start reviewing the cases of these individuals.
John, according to article... Next topic. Why has the government so far refused to convene tribunals that would end this controversy over the detainees' status? John, according to Article 5 of the Geneva Convention, this is what Irwin has been quoting, whenever there is, quote, any doubt, close quote, whether a detainee is or is not a prisoner of war, the detainee is entitled to a finding on the question by, again, quote, a competent tribunal, close quote. Now, Irwin himself is a well-educated, well-read man whose heart is in the right place. And he looks at the situation and says, I'm in doubt. I am in doubt. Is that not evidence on the face of it Irwin's doubts, the doubts of many others, people of goodwill, highly educated, literate, who've informed themselves on the matter, that indeed there is doubt. What would it cost us to set up a tribunal, even if it's as rudimentary as 3 well-informed officers, to go through these cases? Just as a political matter, why doesn't the president say to the Secretary of Defense, for goodness sake, get Erwin Chemerinsky and his kind off my back, set up tribunals? Why don't they do it?
I think
are they worried about precedent? What are they worried about?
I think there's two things here. First, you're right. Why not do it? It could be cheap. It could be quick and speedy. I think some of that is happening now. I think you've seen Department of Defense has announced that they are going to review people. They're saying it's not because of Geneva, but they're doing it for political reasons because of diplomatic pressure and so on. I think the second thing is there's an important message to send about what terrorism is, and I think this is part of the bigger picture of why these kind of issues are important. We don't want to legitimize terrorism, right? You are legitimizing terrorism if you're going to say terrorists are the same thing as honorable warriors who are captured in the laws of war and receive Geneva Convention protections.
So it's the precedent.
I think it's important to send
diplomatic message.
I think it's important to send the message, and law is part of diplomacy, political message, and so on, to say we are devaluing terrorism. We are not going to give terrorists the same treatment as people who fight legitimately.
And you think doing that is illegal or imprudent?
I think it's both. Let me respond to 2 points. First, he says the Defense Department is now saying it's going to create tribunals. And I think that's terrific. It's long overdue. Many of these people have been there for 2 years. I think the Defense Department is doing it because the case is now before the Supreme Court, and the Defense Department wants to seem less unreasonable before the Supreme Court. As for the second point, I do want to talk about what John does, the message that we're sending. I think by holding these individuals indefinitely with no judicial procedure, we send a message to the world of arbitrary power violating international law. He's right. That's why Great Britain, for example, has been outraged, why many nations like Australia have been outraged. And I think that's why what the United States is doing is so clearly wrong.
Okay, questions of jurisdiction. On to questions of jurisdiction. 1950 case, Johnson versus Eisenträger. The case arises from the conviction of 21 Germans in China who were tried by a U.S. military commission in Nanking for assisting Japanese soldiers that were fighting the United States. The Germans are then transferred to a prison in Germany that was under the control of the United States Army. One of the 21 seeks a writ of habeas corpus. The Supreme Court rules against him. The decision, quote, these prisoners at no relevant time were within any territory over which the United States is sovereign, and the scenes of their offense, their capture, their trial, and their punishment were all beyond the territorial jurisdiction of any court of the United States, close quote. Is it not the case that every word of that decision applies equally well to the detainees in Guantanamo, and how does the Supreme Court intend to bend itself around that problem?
For 2 reasons. First, the first thing you said was these 21 individuals had all been tried in a military tribunal. Those being held in Guantanamo have been tried in no tribunal. Second, keep in mind with regard to John's...
He's got a perplexed look on his face.
Because, again, this shows a misunderstanding of the difference between military affairs and domestic law enforcement affairs. A trial is a good thing in domestic affairs because you have truth-finding function and so on. In military affairs, to be tried by a military commission is worse off. You are being treated harshly by the government rather than being simply detained, because under the military law, when you're detained, you're allowed to be released when the conflict's over. If you get tried, you could be executed, you get a sentence, you're punished. And that's why in that system, having a military commission in the Johnson versus Eisenträger case actually was a worse thing that the government did to the detainees than in the current case. And in a way, you're asking for them to all be tried by military commissions, which is a harsher punishment by the government on the people being held at Guantanamo Bay.
That's amazing.
That's because you say, no, that's just...
The reason I say it's amazing spin is what it says is it's better to hold people for the rest of their lives in prison without due process than to provide some form of due process.
First of all, the government has not said they're going to hold them for the rest of their lives. They're getting held to the conflict.
The Secretary of Defense has used the word indefinitely over and over and over again. You can do a Google search on Rumsfeld indefinitely in Guantanamo, and believe me, you find dozens of uses of that word.
I mean, that legally, they cannot be held indefinitely. There's no doubt about that. I'm sure when the government argues the case in the Supreme Court, they will say that. They get held as long as the conflict is over.
You don't mind if we send a tape of this to Rumsfeld?
No, you can
stop using that word.
As long as the conflict is ongoing.
And the conflict is the war on terrorism.
The conflict is a war against Al Qaeda, the entity Al Qaeda. It's not against a war. It's not a war as long as terrorism goes on for. And that's an important point, because we don't know how long a war is going to go on for. We're just in the very beginnings of it, right? That's like saying in 1939 you should have known how long World War II is going to go on for.
You come to us from
they'll be released in 5 years.
You come to us from the Bush Department of Justice. So what you say is of special interest here. But you just gave the war on terror a sharper definition than I've heard from the President, from the Secretary of Defense. You're quite sure that the President would sign on to that notion, that when he said in the State of the Union address this past winter that we've captured or killed some 2/3 of the leadership of al-Qaeda, he was saying, in effect, we're 2/3 of the way to the end of this war?
I think that's essentially true. I think if we effectively decapitate the leaders of al-Qaeda and remove their capabilities to harm the United States.
And that's the policy of the United States government. That's
I think
that has being hopeful or tidying up.
I think legally that has to be the case, and I think all the detention powers and so on are tied to that.
But go on though, because I want to know how the Supreme Court gets around this 1941 decision.
I see two things. One was there were military tribunals there, and there are no tribunals here. Second, when you read that quote, the Supreme Court emphasized they're being held outside the sovereign territory of the United States. Right. I think Guantanamo is clearly the sovereign territory of the United States under the terms of the treaty with Guantanamo.
Under the terms of the Treaty of Guantanamo, the sovereignty of Cuba is explicitly recognized.
Yes, but if you look at the Navy's own website, it says what that means is that if the United States leaves Guantanamo Bay, it's then turned back to Cuba. Ask a simple question.
Is that a legal loophole?
No, I mean, there's a difference between jurisdiction and sovereignty. Right? I mean, I think Irwin's approach to it would mean that federal courts would have habeas jurisdiction over every base abroad, every U.S. base where we have set up a base with a treaty. It would extend jurisdiction to every POW camp we have abroad because, you know, we're exercising some kind of sovereign power over that territory. Cuba clearly owns Guantanamo Bay. We are renting it, right? And it's an indefinite lease in the sense you need both parties to agree to terminate it. But we don't own Guantanamo Bay. It's not part of the United States. I mean,
simple question. Could Castro release the prisoners in Guantanamo? Obviously not, and that's because it is undoubtedly part of the United States sovereign territory.
It's not. Which state is it a part of? Which possession is it a part of? Is Guantanamo Bay the same status as Puerto Rico? Is it a possession of the United States? No, it's a military base that's abroad, just like the German.
Let's put aside issues of authority and jurisdiction. What about plain old American fairness? Irwin's fundamental point, which seems to me as a layman, perhaps precisely because I'm a layman, has resonance, which is that it is somehow fundamentally un-American to take human beings, drag them to Guantanamo Bay, put them in the clink, and either toss away the key or hang it on a rack and say, we're going to leave the key there indefinitely. It's just not fair play. Right. It's not American.
Right. The only thing I think that bothers you, and I think it mainly bothers people in the public, is the undefined time.
The utter open-endedness of it.
I think the important thing to remember is that there is a definite timeline. It's when the conflict is over. And perhaps the political rhetoric about what we're facing is at odds with the legal rules. And those legal rules
you demonstrate such humility before all the decisions of the executive. Except when I push you on this indefinite quality, and then suddenly you know more than they do and say, oh, no, that's just political rhetoric.
No, I don't think that if you asked them and said, we're allowed to hold them indefinitely under the laws of war, they would say, yes, we can. They would say, you know, we can hold them until the conflict is over. And the conflict may not be over for a long time, but there have been long wars before. There was a 30 years war. There was a 100 years war. We didn't know at the beginning of World War II how long that war was going to be for, right? How would we know that World War II?
John, by the way, during the 100 years war and the 30 years war, paying a ransom for, prisoners were exchanged all the time.
I'm just saying the
Nobody stayed in a castle for 100 years.
We've just been fortunate in the last few years to have wars that were only a month long.
Go ahead, back
neither of those, neither the 30 nor the 100 war involved the United States government locking people indefinitely.
Which did not exist.
John describes rightly how September 11th was different than other events in American history, but that doesn't tell us normatively what it should mean in terms of the law. And I think when it comes to those basic principles of human rights and human freedom, September 11th doesn't change that. And I think we really do a disservice to our Constitution and international law when we use that as an excuse for imprisoning individuals indefinitely with no judicial process whatsoever.
Last question. How will the Supreme Court decide?
I think the Supreme Court's going to decide very narrowly, saying that the American courts do have jurisdiction, but they're not resolving anything more than that.
And they will decide on what grounds?
I think they will
say we are
say,
in effect sovereign in Guantanamo Bay?
I think they might do that. I think what they'll also say is that Johnson versus Eisentrager is distinguishable because there some tribunal was provided. I think what they're going to say is that on that basis, courts have jurisdiction to at least hear and decide what's appropriate.
John, how will the court decide?
Unfortunately, I think it's up to Justice O'Connor, and I'm not a mind
Yet
reader.
again.
Yes, and I've written, recently that I think this is a bad thing for the courts and for our legal system to have this kind of common law, decision making based on all the facts. I'd rather have a clear rule. come out of the court on this, one way or the other, so the government knows how to fight. But I think what will happen is that the court will say Guantanamo Bay is outside the jurisdiction of the federal courts, Johnson versus Eisentrager applies, but then say in the case of Padilla and Hamdi, in the Hamdi case, that there will be some...
Which are distinguished from Guantanamo Bay
because they're United States citizens in the United States who are accused of being members of al-Qaeda. And they will get some kind of access to a lawyer, and they will get some kind of hearing and judicial review. And I think that's how they'll split the bill.
And you will find that unsatisfying, because on Guantanamo Bay, the court will reach for the narrowest, most technical grounds.
I actually think at Guantanamo Bay, they will say this is outside our jurisdiction because it's outside the United States.
And just slot it out of court altogether.
Right, and they'll focus most of their attention on how U.S. citizens are going to be treated in the United States, which is going to be the future of the war on terrorism anyway, right? There's going to be what happens when al-Qaeda operatives get into the United States. That's going to be the future. That's the question the court will probably spend most of its time on. In a way, Guantanamo Bay is the past, right? Those are the people we picked up for the conflicts that are essentially ending.
One hopes.
Yeah, one hopes. And so the thing to be worried about is what the court's going to do about the rules going forward, because that will have a very definite effect on how the war on terrorism goes for us.
Erwin Chemerinsky, John Yoo, thank you very much. I'm Peter Robinson for Uncommon Knowledge. Thanks for joining us.
Funding for this program was provided by the John M. Olin Foundation.
We are PBS.